Well, we pretty much already knew this, right? That Bryan Kohberger's motion to dismiss was denied, both portions of it. But at least now we have the papers to match. Hey guys, this is Jules with True Crime Reactions. Now, most of you guys know that Bryan Kohberger filed a motion to dismiss, and there was two portions of it. The morning session of that hearing was about evidence not being submitted and a bunch of more very secretive things when it came to the IgG information, especially. And that was a completely closed session. There was no media. Everything about that hearing portion was sealed. And then we had a public portion in the afternoon that had to do with the grand jury situation. I believe that in this hearing is whenever Logsden let slip the fact that there were several grand jury members that asked for additional information, meaning more valid evidence, more substantial evidence. Now we finally have the documents that matches these things, and just like the hearings themselves, there's a public document letting us know the way that that morning session went, but everything else when it comes to the actual details of the reason why they're denying it, all of that is going to be sealed. And then we also have a document for the reasons why the grand jury situation for the motion to dismiss was also denied. Let's just go ahead and get started looking at those. Now we're going to actually go through the last posted document first because it is just the shortened version for the public order for the denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Again, this was the portion of the motion to dismiss that was closed to the public, and it's a very, very short document. This one, we're going to read the whole one. It states that on August 23rd of 2023, Kohberger filed a motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. On September 14th of 2023, the state filed an objection to defendant's second motion to dismiss indictment. On September 20th, 2023, Kohberger filed a reply to state's objection. A hearing on the motion was held on October 26th of 2023. Kohberger was represented by Ann Taylor, Jay Logsden, and Elisa Massoth, or is it Eliza Massoth? I honestly don't know how to say her name. The state was represented by William W. Thompson, or Bill Thompson, Ashley Jennings, Jeff Nye, and Ingrid Beatty. This hearing was closed to the public and media cameras to protect the secrecy of the grand jury proceedings. The decision will also be sealed. However, the results of that decision are addressed in this public order for the public's benefit. Kohberger has failed to successfully challenge the indictment on grounds of juror bias, lack of sufficient admissible evidence, or prosecutorial misconduct. Kohberger was indicted by an impartial grand jury who had sufficient admissible evidence to find probable cause to believe Kohberger committed the crimes alleged by the state. Further, the state did not engage in prosecutorial misconduct in presenting their case to the jury. Now, see, the problem that I have with this is that we aren't privy to see what their arguments were when it came to all of these things. We don't know what examples they were using for a biased grand jury, or what examples were given for evidence that was deemed inadmissible, or evidence that should have been put into admission that weren't, or lack of sufficient evidence. What were their examples of that? What should be there that they're claiming isn't, or what isn't sufficient enough? What examples did they give over for what they believe to be prosecutorial misconduct in withholding what they're claiming to be exculpatory evidence? None of the stuff that they told us when it came to Bethany Funk and whatever her exculpatory evidence actually was, or her exculpatory testimony could actually be, none of those details have been brought out. To this day, they've never even verified if Bryan Kohberger's team actually went over to interview Bethany in Nevada. Literally no one has said another word about Bethany since those documents came out months and months and months and months ago. So for them to publicly release a document claiming, oh, y'all failed to show us all of that, Okay, well, it's not really any benefit to the public to get this information of, oh, they didn't do a good enough job proving it to us if we don't get to see the proof that they supplied, if that makes any sense. Now, the only thing that this document shows is that in order for the court to make a decision, because this is all about the grand jury and trying to get that whole grand jury indictment thrown out, not only did the state have to hand over the court records, the transcriptions, all those things over to the defense for them to be able to go through, but the court also had to have access to all of those things in order to go in and listen and read through everything that happened in the grand jury. They would have to be able to do all of that in order to make a decision. This is just the paper trail needed to show that there were other peoples that had access to it. Now we have the first and our last document. Now, this is a 13-page document about the reason why the motion for dismiss indictment for inaccurate instructions to the grand jury is, obviously denied. Now, I never once thought that this was going to do anything for them. I never understood their reasoning for wanting to fight it with this, for claiming that the grand jury wasn't instructed correctly and saying things about how there was something on one of the forms that was wrong. Because in my opinion, you're basing that on items of instruction and forms of instruction and forms that are used in this grand jury portion of the state of Idaho. Every single grand jury is using this exact same format. Every single grand jury is given the exact same set of instructions. None of the things in the way that a grand jury would actually take place and the procedures that happen would change depending on the case. The whole point of the grand jury stays the same regardless of what's actually being, shown at the grand jury. There is a basis that they're supposed to have to follow, okay? For them to have thrown out Bryan Kohberger's indictment based off of that situation, and this is my opinion, this is what I've said and what I should have said at the beginning of this video, so let me just go ahead and put my little disclaimer out here now. Everything said in this video is my opinion and my opinion only, and just like everything else in this case here, everything mentioned is alleged. But in order for Bryan Kohberger to have won this one, the state would have literally have had to go in and undo the indictments for every grand jury that used those exact same sets of instructions and that exact same form. For how long? For how far into the past would they have to go and redo all of these cases? No, that was never going to work. I never understood why they were trying to throw something out here that could technically be such a blanketed situation, but have such a mass effect if it was actually approved. Literally, if they were going to sit here and say, oh, yeah, the instructions were incorrect, we see exactly what you're talking about. Yes, this form is inaccurate. Yes, we see exactly what you mean. They would have to go in and undo how many grand jury indictments? Thousands? They're not going to try to do that. Now, I have gone in and I've read all 13 pages of this, and I personally did not see anything new, anything special. It's the exact same argument. It's the exact same argument they've been having forever, whether it is beyond a reasonable doubt or whether it is probable cause. This has gone back and forth, and this has been their argument. And this is the whole reason why I said if this was to change just for this one case, they would have the obligation to go in and undo things for hundreds, if not thousands, of other cases. And again, I'm going to have a link to these documents in the description box, but I personally don't find a reason to sit here and waste you guys' time reading through all of these pages. It's a whole lot of citations, and I'm pretty sure that Lawyer and a couple other channels will go through all of the documents, all of those legalese things with you guys. But in my opinion, and the gist of all of this is that this is the same argument. This is just a repetition of all of the same things that they've been using to fight this argument this entire time. And all they've done is come back in, put it all in a big, huge summarization, to say this: "The arguments from the defense for a beyond reasonable doubt standard for a grand jury were historically interesting and creative, but do not overturn Idaho court's interpretation of the statute, the case law, and the criminal rules, specifically Rule 6 through 6.8 ICR, and that the standard for the grand jury to indict is probable cause. Therefore, the court denies Kohberger's motion to dismiss the indictment based on his claim of inaccurate instructions to the grand jury in order to warrant an indictment." But that is it for the newest documents. No new information, no new actual details when it comes to the case itself. Pretty much this was just the paper trail of what we already knew when it came to the motion to dismiss being denied. But let me know what you guys think of this. Was this something that you already knew was happening and we were just waiting on the paperwork to drop? Or is this new news to you? Let me know in the comment section. If you liked this video, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.